Should be right on.
Excellent.
I've got it. There she is. Welcome, Senator Ellicott.
Good morning.
Hello.
Morning.
Okay, we've got everybody on. Representative Barlow, would you like for yourself or for me to kind of be the overall run of the meeting? I'm happy either way.
Well, rock, paper, scissors. You're the rock. Go ahead.
Take off. You can start at the top or the bottom. You're picking. These are easy topics.
Sure. So, so thank you, Mr. Chairman and colleagues. I understand there's about 30 people that are on the call with us or on YouTube viewing us. So we welcome them. This is a conference committee on House Bill 1002, Senate File 1002. And we have some differences, and that's what we're here to discuss and see so where we can find some accommodation for each other. I guess I'm going to just kind of broad categorize it, and Mr. Chairman, anybody wants to jump in anytime. I think we have workers' comp, and while I think there's something that we have a couple mirror amendments, and then with some technical corrections. I think those are easy to overcome. Then there's a couple new components, new ideas that come out of the Senate that we could probably have a discussion about, and then there's the WCDA or the renter forbearance, that type of issue, which we're very close on as well. I would suggest there's mirror amendments, and then there's one modification to our side on a mirror amendment, and then we have a third reading amendment, another amendment, third reading that we can go. It does some other things too. So I think on the WCDA and workers' comp, we can get pretty close. There's one amendment out there, the Boner amendment. Yep, sorry, Mr. Chairman.
Let's get everybody to mute. I'm getting a lot of background noise, so I see part of us aren't muted. I'll mute.
Thank you. I guess I assumed it was, anyway, I apologize. So then we have the program bill. There was a Boner bill, which at least by our estimation, looks like a lot like something that came out of 1001 with some added language for fees and other things and programs. So I don't know how we'd like to do it. Take the low hanging fruit first, or if you'd like just to work through that. And then we have the liability issue. And that's probably the one we will have the most discussion. So, or we go the opposite way. I see Senator Anselmi Dalton.
Mr. Chairman.
Go ahead.
I would request that let's start with the difficult issue and get through it and see where we're at on civil liability. I think that's let's start with the hardest battles first and get over it since we're all a little tired.
Without objection, Mr. Co-Chairman, we'll do that.
Yeah, I guess I see the other way. I see 80% we can probably agree on. If there's 5 or 10 that we don't, we do the opposite. But if we want to start at the opposite end,
We'll give you the first win. We're going to let you take the low hanging fruit first. That's your win. Then we get ours later. Okay.
well, it's your call. If you want us to talk about the liability, let's just poll us and see where we are on liability, and we can go from there. I guess on the House side, I'll just summarize where the House is, and Mr. Chairman, you can summarize where the Senate as a body was. The House did two things. We did not vote for introduction of a mirror bill that was 105 on the Senate side, and then this amendment was brought, a mirror amendment, I believe, to the one that's in the Senate, in your Senate file. Your Senate adopted amendment was brought. It was challenged in Rules Committee and was ruled by the chair as not germane, and the body did not choose to override the ruling of the chair. So we have the House has twice said we are not interested in that discussion. Thank you. In this bill, in this session. Thank you.
Mr. Co-Chairman, I guess we'd like to go through the process of why we did what we did and see if there's some middle ground. I think the Senate was very sincere in their want to help, in particular, small business owners as quickly as possible with some kind of liability, and would kind of like to hear, I'd like to hear my other committee members, as well as your thoughts, what is wrong with coming up with some type of immunity right away, knowing full well that we can do some further fixes on it in judiciary down the road. But we've got a huge outcry, and I'm sure you're hearing it on your side as well, of people that I represent, particularly business owners, that are very worried about, as we open back up, what the effects are of liability upon their business as they open their doors. In particular, with the lack of guidance that we've got out of the state on it, how do we protect our business owners from yet another crisis in the middle of a crisis? And so I'd like for my co-members to both visit and then let you guys kind of give us your rationale of why you're wanting to deny any type of immunity to business owners in the short term, because we do sunset it. With that, I'll yield the floor to a couple of lawyers that I happen to be on my committee with me. Senator Salmi Dalton.
Thank you, Mr. Chairman. As a business owner, I'm just going to go through my concerns for small businesses. I think obviously Senator Nethercott is more the legal maven than I am. So I will, of course, defer to her expertise over mine in that regard, but I'm going to just go through as a business owner quickly. I'm worried about small businesses who are opening up. I, as a small business owner, have concerns, and I'm trying very hard every day to do everything right. I take the temperatures of every one of my employees every day when they come in. I record it on a piece of paper because I know, as a former attorney, that he who has the most documents wins. So I try really hard. I write their temperature on a piece of paper, and they sign that they don't have any of the symptoms of coronavirus. I gave my van driver the guidance from IHG to say, here's what you do in the van. You disinfect it. I mean, not that you can always buy Lysol. I mean, my poor housekeeper is so nice. My head housekeeper, she goes and runs to Walmart to get Lysol at 7 a.m. They'll only let her buy 2 cans. So we have it to spray in the elevators. We disinfect everything. We put up plastic screens. We've tried very hard to be very, very careful, but people are coming in and staying at our hotel. We had, we're the quarantine hotel for the hospital. So they do call us if they want someone to come down who wants to quarantine themselves. That's our job, and we've signed an agreement with them. Luckily, we haven't had any outbreaks where we've had to be used for that purpose. But before I let Old Chicago open in my hotel, they were when the governor allowed the restaurants to open, I was very concerned. And I called them and I said I wanted to make sure I was an additional insured on their insurance policy to show that, and they sent me a form, it was wrong. I sent it back. I said it had to be right before I'd let them open. I mean, because I don't want to be sued, and I will be sued. I mean, the point is, if they trace a cluster to Old Chicago that happens last Thursday when they opened up, and they say, okay, there was 10 people at this table and they got sick, and we're going to say, that's what an attorney has to do. An attorney has to sue everyone. They'll sue the hotel because that's where the restaurant's located. They'll sue me, my hotel, and obviously they'll sue Old Chicago. They'll sue the people, perhaps if they thought they got it from the person next door that was sneezing, or the server. I don't know, but I'm just saying I have concerns, and these lawsuits are starting already. There's lawsuits in other states. So I did agree that Senator Kinsey's draft in the Senate File 1005 was very broad, and we agreed, and we narrowed it down based on some language. I think that Senator Grew and Senator Nethercott had been working on. I took his draft bill because I think it reflected the concerns of the House to be much more, to include, for example, that you couldn't, you would still be liable if you had willful or wanton misconduct, or if there was reckless infliction of harm or injury, or intentional infliction of harm or injury. I also put a sunset date because I heard that was a concern in the House, that they don't want to go on forever, so it would end on December 31st, 2021. I also heard there were concerns in the House that they didn't want it to go on, that they didn't want to be other pandemics or other coronavirus cases. So I changed it to only be COVID-19 to reflect that concern. Senator Nethercott was concerned that it didn't have sole proprietorship in the business entity definition, so I did add that into it as well. And I also added it to be off premises because there was some concern. This was not necessarily from any legislative member, but from other people to say that they were worried that some things happen off property. For example, rafting companies, there may be 10 people in a boat and maybe one of them is a non-indicative carrier of this, and they get sick and then they sue the rafting company, but obviously it's not on the premises of the rafting company. So I did add in off premises as well. I mean, it's hard to strike a balance between how to give immunity. You want to be fair to both sides. I literally believe that I'm taking every precaution I can, but I guarantee you, I'm using my baby's thermoscan thermometer from when that's 24 years old at my work with these. I bought the little coverings and I'm using that for my employees. And I have a forehead one, and I got one thermoscan one that's, the one that's nice, that you don't have to touch them. But I've ordered 2 more, and I've ordered Purell hand stations, the big ones, but those are on back order, so I don't have those yet either. But we do have alcohol, and we wash our hands and we go through all that. But should I be right now? I'm asking, should I be? Is it reasonable for me? Should I be taking the temperature of every guest? Should I be asking them to send me a query? I just worry about freaking them out. So it's a balance. As a business owner, trying to use your best judgment and reasonable methods, I am trying my hardest to do everything I possibly can, but I still worry about a lawsuit because that's the way the law works. If something happens and someone dies or someone gets sick and is in the hospital, they want to sue. And so I'm just trying to strike a balance for the small business owners as we reopen up without guidance, because you can't retroactively go back and say, oh, now, if something happens tomorrow and we wait till July for the special session again, if I have that lawsuit tomorrow, you aren't protecting me if I've taken everything I can, and I think I am doing everything I possibly can do. I think I'm doing better than most businesses. I'm making face masks for my employees. I have a woman who I just paid to work at the hotel by herself alone in the lobby, and I pay her to make face masks for myself. Yes, like Representative Wilson is wearing, she makes face masks all day. That's, I pay her. She mends curtains and she sews face masks. And I told the hospital asked me to make some, so she's going to make some too. And I ordered Disney fabric so they would be cute for, I know that's not great, but for the children if they come. And I thought, so I ordered all this Disney fabric to have her make some for the hospital. So at least it'd be something better than an awful face mask. At least it'd be sort of a nice thing. But I'm trying my hardest to do everything I possibly can. And still, I don't think I should be subjected to lawsuit as a business owner. And so that's why I brought this amendment and tried to tailor it to fit the needs. And then I feel like then judiciary can look at it. I'm on judiciary committee. I believe in my chairman. I know she's going to go through the legal issues with you. She's smart, but I wanted it to be fair on both sides. And I think then if we need amendments, judiciary can act quickly, and then it'll come up in July if we need some further tweaks. And so that would be my business owner perspective. Thank you, Mr. Chairman.
Is there another cop?
Thank you, Mr. Chairman. It's good to see everyone this morning, those good House members. And I appreciate the opportunity to provide kind of a statement on this issue. So I think Senator Anselmi Dalton has done a really excellent job of outlining the fears of many of the business owners. As we just heard, the litany of actions that she has taken, I hope with the primary purpose of protecting employees and customers, as opposed to a primary concern out of liability. As an attorney who has a firm that's practiced in this state, and as a senator, and I do both plaintiff and defendants work, and my firm does both sides, I just want to urge a measure of calm to all the businesses and people in Wyoming, that, believe it or not, Wyoming precedent and this country's precedent when it comes to issues related to liability, we have really strong laws that protect both parties. And so I urge Wyoming businesses to have faith in our system, whether or not this particular issue passes now or in the future, that your Wyoming courts will provide meaningful justice and an opportunity to be heard and a balancing of interests. So that's important, is just to kind of bring the conversation down. I do not believe that there will be a flood of litigation. That's my personal opinion. So my level of fear associated with this is lessened, maybe than some. And remember, I am a business owner too. in Cheyenne, Wyoming, near the Colorado border, which is one of those epicenters. And so I recognize the importance of an exposure to liability and risks as well. That said, I also support the effort to respond to the perceptions of businesses in Wyoming over this concern regarding liability. I do appreciate the work that Senator Anselmi Dalton did in her amendment. I think it is far and improved above what we saw earlier in Senate File 5 and in the mirror bill in the House that was broader. So I do think that this is much improved as it relates to that concept. You probably may have heard my disappointment in the process associated with how this issue came up. I felt it was important that we respected the decisions of Management Council in light of our limited time, limited resources. And so I wanted to honor the decision of Management Council to allow the Judiciary Committee to really vet this issue. The Judiciary Committee hopes to be able to address this particular topic here very shortly via another Zoom meeting to deal with our COVID-related topics as assigned. And of course, we all know that it's very likely we will be coming back into a special session at the end of next month. So from the public's perception, whether we're able to solve this now or not, I do believe solutions are coming your way through a meaningful conversation. I have expressed a lot of frustration over that process. However, I think the work and the subject as found in Senate File 1002 and the mirror bill and House Bill 1002 is critically important that those issues pass. I think good work has been done there through stakeholder involvement. And so I think it is fundamentally important that those topics move forward and we're able to provide those solutions to the people of Wyoming as quickly as possible. I am confident we can resolve this issue of liability and we can provide those solutions to Wyoming businesses so we can continue to open our doors and get back to normal. So with that, I look forward to having a good conversation about where we can go and the solutions we can provide for Wyoming with this bill.
Okay. So, Mr. Chairman, I see your Senator Anselmi Dalton wants to say something. Go ahead, Senator Anselmi Dalton, and I think the House would like to make some comments too.
Oh, you understand. I just wanted to make it clear that, Mr. Chairman, thank you, that I mean, I talked about the liability more just because that's what this is about, but I'm very concerned about my employees. I've allowed this one woman just to isolate herself and sew masks all day long because she's 70, but she wanted to work. She said she was bored at home, so I'm paying her to just sew masks and drapes all day or clean lampshades or whatever we can come up with for her. I'm very concerned. I don't want her, you know, I know she feels a little sad being by herself, but we go see her and drop things off, but we try to be careful, and I care about all my employees. Mine have been with me forever. I have people that have been with me for 40 years because we don't treat our employees poorly. So if I in any way sounded like I don't care about my employees or my guests, that's my primary concern, of course. I just, I just didn't want to sound like I was callous. That's not where I'm at. I love my employees and I think they love me or they wouldn't stay with us so long.
Thank you. I'm sure that is the case. They love you and we love you too, Senator Anselmi Dalton. So maybe we'll go through, Mr. Chairman, if you're okay, we'll just go through our House members and kind of give some feedback from their perspective. And we'll start with Representative Wilson, Chairman Wilson.
Thank you, Mr. Chairman. Make sure I've got all my, I had to move up to the balcony because it was a little loud on the floor. So I'm kind of crouching in the corner of the balcony. Thank you, Mr. Chairman. I've been fortunate in a way in that in my own business, I work from my home. And so I have no troubles. And as a matter of fact, I've actually had more business than before as a result of the coronavirus. So I'm not looking at it at all from the point of view of my own situation. I felt like this is a topic that obviously is going to have very broad interest. And in general, during session, regular session, and now I don't like to see really substantive issues come in as third reading amendments in the dark, which we've seen that over the last few years with a number of topics, and I typically vote against that just on the process side of things. And not being an attorney, but I've looked at, some of the standards that we have considered. And I just want us to be able to find a balance between employers like Senator Anselmi Dalton, who is obviously going beyond, I mean, I don't want to say beyond the call of duty. She's obviously doing a fabulous job. But then I also certainly hear from people who, think COVID-19 is all in everybody's head and masks are for wimps and such like. And I would be a little apprehensive as a customer going into a business where the owners were evidently heedless for ideological reasons, and then I might have no recourse. So that and it's difficult on sort of short notice to find the balance in drafting things like that. So that's really all I have to say about that. Thank you, Mr. Chairman.
Thank you. Representative Conley?
Thank you, Mr. Chairman, and thank you all. I think I want to start with talking a little bit about the substance, but then honestly talk about the procedure and actually kind of follow up on the good chair of Senate Judiciary's comments regarding the importance of this issue and her committee taking it up. I appreciate the good bringer of the amendment talking about her own business, but it's certainly my understanding, and it's explicit in the statutes in 35-4114, that immunity is granted, right, to employers who follow with good faith effort any of the rules of our state health officer. That immunity already exists. There was also mention about concern of lawsuits that happen tomorrow. My understanding from a recent article is that, yes, there have been some lawsuits, but not that many. And half of them were against that Princess Cruise Line to start with, right? Right? Those make sense. Very few and against those cruise lines that kept people on those ships, okay? But where I really want to turn is kind of attention to the process, because this is a biggie. This is a biggie. We have an article, a Wyoming Constitution Article 1 right as citizens to use our courts. We do, right? That's fundamental. That's fundamental that we have access to the courts, and an immunity provision modifies that, changes it, takes away one of our citizens' fundamental rights. I serve on management council. This is a bill. We had 4 bills, 3 that went through management council, 1 that went through minerals. They were vetted for about 6 weeks, a wide variety of hearings. One management council meeting had hundreds of people paying attention, hundreds and hundreds, more than we have when we're at the Capitol. For 6 weeks, my email has been blowing up with comments about those bills, including 1002. I've paid a lot of attention to the provisions in 1002, right? The unemployment insurance and the ability to kind of address issues regarding experience ratings, workers' comp in terms of a premium holiday, right? Protection for renters and evictions, right? Each of those have been debated, vetted, fine-tuned. And then we come here and we have an enormous, enormous issue regarding liability that's far beyond workers' comp, right? It's far beyond, right, a provision of that bill, to the point that there had to be an amendment to the catch title, right? This has not received kind of public vetting, right? This has not received the kind of oversight of a committee. It has not allowed public participation. I understand that we went into a special session a dozen years ago over tort liability, right? This issue is as big as that. And I want it thoroughly vetted, and I want it thoroughly vetted by our standing committees. And it sounds to me like the good chair of the Senate is ready to do that in her committee. And I believe that that's where it should be. It has no place in this bill, but it does have a place in a month in our Joint Judiciary Committee. So with that, thank you, Mr. Chairman.
So thank you for everyone's comments. So I think I'll just circle back to what I said in my opening. You know, we both have a position, a House position, if you will, a Senate position. I personally, the process is, as my colleague Minority Floor Leader Conley said, the process is where I have the biggest trouble. I do agree that this version is less offensive than the 1005, which was way out. Just I couldn't even understand how that could be possible. But anyway, so how we go forward with this, I guess, depends on there was talked about some accommodations that were made in this proposal, in the proposal that's in the Senate amendment. And, you know, if there's a possibility of, for some people, more accommodations, for others on my committee, there is no accommodation except a full vetting process, i.e. through a standing committee. Maybe there's some room to talk. I don't know where how you want to proceed, Mr. Chairman, but we come back in well, we've got a little bit more time. We've got another half an hour or so. We can visit through this more, or we can visit through the rest of it, see if we have accommodation there, and then go back to our respective caucuses and bodies and visit about what we want to attempt with this. I think you've heard that my body is fairly resistant to anything except possibly going with a standing committee, taking it up in a second at this point, unless you have another way forward. Thank you. Go ahead, Mr. Chairman.
I've got some comments and I'll kick back. I took a few notes and we'll visit a little as we go. I'll start with as far as management council, and I am on management council, and I did a major kickback and asked for this to come. And back to emails and comments you've got, I can show you not dozens, but hundreds of emails from business owners that are asking for help. They expect it, they want it. We've made it very clear when you look at the findings in all our bills. These are special times, and that's what the special session's for. And I feel clearly, you know, you talk about notice out of third reading out of nowhere. Well, yes and no. There was a bill filed. You had notice of where our side stood because the bill passed solidly on our side, similar to the margins on the other side. And when your side refused to take the bill up through several various means.
Mr. Chairman, just to be clear, that passed yesterday, correct?
Yes.
Okay, thank you.
So I get it, but it was there. The debate was there. So you should have expected that with the strength that the bill passed after it went down, that there would be something coming. And absolutely there was. The job of a conference committee is to reach a compromise somewhere between the positions, and taking a position that you're just going to kill the bill probably is not actually a compromise. It's a pretty solid way to kill a bill. And you know what we're really trying to do is find some middle ground, but we're not seeing a whole lot of that middle ground. And
just to be clear, I don't know that anybody on our side said kill the bill. In fact, the last thing I said is if there's a way forward, we can go back to our different sides and figure out what that is. So let's be clear about that, I think, Mr. Chairman.
so what I'm asking is, where's the middle ground at? Because I guess I didn't hear any of it on any of your side. I did hear from ours that we're willing to look at some changes, propose something to us. I think we also need to understand we know another special session's coming. And if there's something there, this is definitely going to be brought up. It's a topic for judiciary. And there's probably some fixes. And I would almost wager you that out of these three bills we have going, that nearly all of them will have some type of fixes at the next session that comes through. Representative Conley, happy to
Thank you, Senator Driscoll. Well, I appreciate what you say. It really concerns me to hear right now your acknowledgement that there will be need for fixes. This is too big of an issue to come back in a month and say, oops, we've made a mistake here. Again, this is limiting our citizens' right to access to the courts. It's an issue that needs to be thoroughly vetted. I have true faith in our judiciary committees to do this right. This provision right here, again, is just way too big, right, to get it wrong today. Thank you, Mr. Chairman.
Well, I guess on the fixes, and I'm going to answer. I said fixes in all the bills. I didn't say fixes in this one. I said in all of them. Because these bills all came at a pretty great rate. And, you know, I've been here for 10 years. And I've done lots of changes in the green books down the road. It's not unusual. And these are unusual times. And this is not a blanket immunity that's wild. Read the bill carefully. If you've willfully and wantonly, or you haven't followed it, you're not covered by it. And, you know, I think this is a reasonable compromise that falls in there that I think you're doing a real disservice as we get ready to reopen if we don't acknowledge it in some reasonable fashion. And I think there is a way, if you can open your mind to think about it. We've got a broad range of areas that we can work on this rather than just saying no.
So Mr. Chairman, I guess you've laid down the gauntlet. So you come back with a proposal that you think gets to where that is. And we'll find a time to reconvene when you're ready. Because I mean, that's where you are. You're saying there's a way forward, you bring it to us. You have the proposal on the table. It's your proposal that's on the table, Mr. Chairman. Our proposal is, we don't have this. That's your proposal. So if you think there's a way forward, you bring it. You heard what one of my members said, there's no way forward, but you.
Well, I guess that's what I'm finding is the way in between is for you to tell me, is there anything in between from zero on the thing to over here? Because I'd like to see if there's anything, if you can even leave the title in and pass it in the bill, because I'm not seeing that from your side. And that's the whole idea. Why should I come halfway to have you tell me that you'll accept nothing other than zero? The true art of compromise means that you actually move something from a zero position.
And like I said, if you have something that you think brings us to that somewhere, then make the offer.
What would you like to see? I don't know where even to start at. I don't know where the problems are at other than no. Senator Dalton.
Thank you, Mr. Chairman. I mean, I thought that I was doing the art of compromise when I took the legislative work of, I asked Senator Grew for his draft. I guess that Senator Chairman Nethercott was working on with him for weeks and weeks. So it hasn't been unvetted. This is her draft of some of the legislation. I apologize because I didn't know who I was working with, Senator Grew. I just had been talking to him. I also serve on management council. Go ahead. I'm sorry, Chairman.
That's a misstatement to state that I've been working with Senator Grew for weeks and weeks. Other members of the Senate had asked if I would be willing to take up the issue in the Judiciary Committee as chairman. I acknowledged that I would. I knew that they were working on a private bill so that the Judiciary Committee would have something to start with. I thought that was prudent in light of the immediacy of the situation concerning a special session. So I provided materials from other legislation that was being considered across the country to Senator Grew to review and work on. I was completely unaware of Senator Kinski's bill and saw it for the first time at 7 o'clock the night before our special session began. And I also was completely unaware of this particular amendment coming onto this bill until it was published. And so that's my work for weeks and weeks and weeks. Again, I would like to say that I support the efforts of protecting businesses and responding to that perception. I do not want fears of liability to slow the reopening of our economy. However, this process has been frustrating, but I also recognize the needs for business. I think that the amendment is significantly improved from Kinski's bill. I think it helps to strike a balance in many meaningful ways. But I just want clarification there. I support the need to protect business. I think the perception in this case is very dangerous to our economy, regardless of the reality, and therefore we have to respond in some way. The sunset provision, I think, helps alleviate really significant heartburn that I might have over it. And I think some of the standards that Senator Anselmi Dalton has included in there also alleviate some of my concerns. I know, speaking with some of the other lawyers across the state that I quickly gave the bill to yesterday morning, agreed with some of those standards needed to be in place that are now found in that amendment. So I applaud that work and that effort. But I just want to be clear, I'm not a co-sponsor on that amendment.
I apologize.
And so, you know, again, I appreciate the work, and I would pass this legislation right now in order to see it all move forward, and we are working in the right direction. I think it's very important for us on this conference committee to not let the other issues that have been worked so hard in this bill and provide meaningful solutions to the people of Wyoming, that we don't get tripped up over this issue. I would hate to see this bill fail, and it is fundamentally important that we pass it. So I do think we need to take concerted effort to understand where middle ground may be reached and compromise may be done. I think it's difficult. I think Chairman Driscoll is in a difficult situation to start negotiating with himself. And so perhaps some solutions would be helpful to have a discussion of any ideas for where the House would like to see changes. I also want to express that I believe that the Senate, Senator Anselmi Dalton and the chairman wanted to go straight to this issue because I think we're comfortable with all of the other issues that the House has achieved in the bill. And so this bill can pass, but for this one piece. So if there's any way that we can move it, we should.
Mr. Chairman.
Yeah, go ahead, please.
Thank you, Mr. Chairman. I just wanted to apologize. I did feel terrible about, I should have said the draft to Senator Nethercott. I felt terrible about that. I do apologize again, Senator Nethercott. It was my mistake. I was really just trying to get some House support. So I was sending it to different people in the House because I felt it had Senate support. And I was just trying to get my 6 people lined up and, you know, trying to also be in the proceedings. It was really very difficult. And I tried to take every concern I had into account. I felt bad torturing LSO with various amendments to try to take different concerns into account and to get a finalized bill that mirrored Representative Stiss in the House. And then after that, I even changed it to pick up other pieces. So I do apologize that in my hurry, I dropped the ball with you.
Go ahead, Senator.
Chairman, I guess we'll kind of leave it at this. I got just a couple party deal. One, back to timing. Multiple other states have already passed this legislation with similar notice to what we've had. Idaho, next door to us, has it passed and signed into law by the governor, and it's been done. The sunset should give some relief to everybody. And I fully agree with Senator Nethercott. I think we'll drop off this call and let you come back. But you folks, like I said, pick something from the title on if there's anything other than no. Our body, it was very strong, as yours was, on where they're at. And I agree fully that I really do not want to endanger this bill. I spent a lot of time working on a management council. We've worked on it, and I think it's foolhardy for us to endanger the bill over people totally locked up. There should be a middle ground somewhere we can get to, and I truly believe the ball's in your court. It's passed, and it's passed strongly out of our body. And it's up to you folks to see if there's anything in that amendment that's palatable, and we're open to look at anything that falls in there. And I think for you to have a private meeting of yours, and if you can find something better than pound sand, it's probably going to be at least looked on as a good move on your part, and maybe play an effect on where the bill falls in between. We both have to take whatever we come up with back to our respective bodies and pass it. So my goal is to have this piece of legislation passed. It has way too many other important parts in it that we have people depending on us for it to come through to kill it over a knee jerk. And I guess for you folks to, and it's back to having some more time, go have a meeting and we'll meet again in an hour or so and see if there is any piece of ground that we can work on there.
Yeah, Madam Minority Floor Leader.
Thank you, Mr. Chairman, and thank you all. I'm curious, I'd like to put it back on the Senate. There are some Senate amendments that we haven't talked about. In particular, there was, I believe, an amendment by Senator Boner. There's another one, I believe, by Senator Kinski. They have some provisions in them that I am not completely comfortable with. Right. And I remember Senator Nethercott just said that she feels as if the Senate could kind of adopt the House position. I'm willing to kind of consider some of those other amendments from the Senate that honestly are quite different than what the House passed. And wondering if we can talk about, for example, kind of inclusion of those Senate provisions, with the exception of the one that we're talking about right now, and that being a compromise. So not a compromise about the language of this particular amendment, but looking at all of the amendments together. And in the same way that we do the budget bill occasionally, is that we accept one amendment and we reject another. And that to me would be a way of going about compromise rather than looking at each one of these amendments separately. And so I'm curious, Senator, how you feel about that as a method of compromise.
So I will tell you, everything is on the table. We're willing, but at least for this first committee, our bodies made it abundantly clear that this was a key portion. It was a bill that passed, as I said. It also was an amendment that passed. So my guess is if you caved on every other position and pulled this provision out, you've got a very grave chance that the bill fails regardless of how you negotiated it. My job is to get something out and get it passed. We've spent a lot of time. I'm trying to find a middle ground, and you continually come back around and try to make me negotiate with myself on my position. And, you know, mine is this, and it's really clear. How do we find middle ground on this first one in some way? Or is there any middle ground? And if there is none, I'm guessing I'm going to go back to our chairman and ask him to appoint another committee, because I'm somewhat uncomfortable going into this and facing my body with a piece of this that is the major piece probably to them, and telling them that here it is. I think you've got a real chance then that we're back to, do we have a bill or not? And we have way too much invested in this bill to kill it over one amendment. Let's see if you guys can find anywhere that's even close to a middle ground.
So just to be clear, you said you couldn't do anything without this, and you're saying we can't do anything with it. So I think let's expedite that. That's exactly what I think I understood from your statement, Mr. Chairman. So let's expedite this. Let's both, and we'll poll our committee, we'll poll the committee. Let's both report that we couldn't come to anything out of our first committee. Let's both go back to our respective presiding officers and report that. And if they choose to select a second committee, maybe it's us and maybe it's not, to come forth with ideas, we both have some time to think about what that would be. And I'm just going to look to my House members to see if anybody, first, Mr. Chairman, you can do with your Senate members, to see if that is something that would be acceptable to Representative Wilson and Representative Conley.
Quickly, Senator Salmi-Dalton.
Thank you, Mr. Chair. there was in the House version a good faith exception in the bill, and I was going to throw that out as in the STIT draft that, you know, I would be happy to say could be a compromise to add that back in if that would help. And also just wanted to point out that, you know, the tricky thing is that insurance companies like to, you know, settle these things. They don't want to litigate them. And I just am trying to get us to a point to protect our small businesses now. The ship of liability is sailing. We can't retroactively fix it. If I get sued tomorrow because Old Chicago has a breakout tomorrow, there is no fix for me as a business going forward. I don't think we can fix it retroactively on July 1st. And if I think we were acting like that it can be fixed retroactively, and it's not the case that that can happen. And this is the case for every small business owner. And I didn't say, oh, you could be willful and reckless and don't care about your patrons. I mean, I care about my people. I don't want to get sick. My poor mother's stuck in Arizona. I told her not to come home. She's 85. I'm like, I'd like to see my mother. But I'm like, don't come home. I don't want you to get sick. I could be a carrier. I mean, I worry about my employees. I tell them, don't get so close. Remember the distance. I mean, I am trying really hard, and other small businesses are trying to. And if they make a mistake, because maybe they're not a lawyer. I am, but I don't practice anymore. But the point is, I do try to take all the precautions necessary. And these other businesses need some protection too. We have to care about our small businesses opening, feeling like they're protected. They shouldn't have to wait till July 1st to be protected. If Management Council, Ogden said, pardon me, Chairman Driscoll was supportive of this idea on it. I was supportive of this idea on it. I have obviously been concerned about it, and I just wanted to point this out. And obviously, Senator Dockstetter's on this bill. Senator Grew was in favor of it. He's on management.
We're good. I think we're gonna have to go to a point.
I just wanted to point these things out.
Senator, another comment?
Thank you, Mr. Chairman. One thing I want to make sure for the public that's watching, and as part of this conversation for business, there is immunity already. And if Representative Connolly can read that statutory provision again, I don't have it quickly in front of me, but I really think that that's important, that as the entire legislature, as we have these conversations with our communities, the wisdom of previous bodies passed this law. And this is actually not a unique law to Wyoming. In fact, if you look at some of this COVID-related tort litigation conversation, what we currently have on the books is what many states are actually passing, is the reality of some of these conversations. And so there is immunity in the state of Wyoming as it relates to this type of liability, so long as a business is acting reasonably and consistent with county or state health orders. So regardless if you agree with that or not, the fact is there is laws on the books providing immunity for business owners. And so I just want to make sure that the public is aware that there currently are protections in place. And so can we maybe have the conversation starting from that reality as opposed to full immunity or no immunity in the state? So we actually are already in the middle of the road. So when we look at that statute that is currently on law, what about it is unsatisfactory to you, Senator Anselmi Dalton, as a business owner, or it doesn't go far enough? And so maybe that is a more appropriate question to actually get to the substance of whatever perceived dispute might be.
Mr. Chairman, I have a statute 35-4-110, spreading contagious disease liability for damages in civil action. Any person guilty of violating it, in addition to penalties, shall be liable in civil action and damages to any and all persons who may from that cause become infected with such contagious disease. The damages shall be so assessed to include, in addition to other damages, all expenses incurred by reason of such sickness, loss, time, burial expenses, and such action may also be maintained by the representative of any deceased person. So I'm just giving you 35-4-110.
Representative Conley.
Yeah, and thank you. And then you need to follow along in the statutes with 35-4-114, which says that immunity is granted as long as there is a good faith effort to follow the instructions of the state health officer. We have the immunity in the statutes right now. And I so appreciate Chairman Nether kind of de-escalating kind of that conversation and saying, what is it that doesn't exist right now that we need to shoehorn in this amendment into an existing bill? Because we already have it in statute. And I'll go back to my concern that when you take away kind of individuals' rights to have access to the courts, I'm deeply concerned. And I'd like to see a standing committee actually kind of take the issue up, because we already have that immunity in our statutes.
We're pretty circular here, and you know the Constitution's clear. So let's go back to where Chairman Barlow was at and pull
So just to be clear, I don't know that we're circular. I think we actually got a starting point with Senator Nethercott's point. So maybe if your committee would start from there, does your body have the same understanding of what that's already available? Or do you believe they have that understanding that's already available? And if that is where it starts, this new section, this new proposed amendment is a completely different section of law, as you will note, and not associated with the public health issue. So I guess maybe let's have that conversation, or maybe it's Senator Nethercott that follows up on that. But what is gained, except how much more is gained than what is already there? Chairman or Senator Nethercott, somebody just tell the body, tell us.
It's a lot. We had an outcry from business and they wanted something done. And I get what's there. I get the other end of it. But the bottom line is this, folks. We're at a point that we passed an amendment, and our position is to have that amendment be a part of it. And it's a strong statement in a time of crisis. I have made the offer to you to make some ground in between, that it's important to our side that something's there. Without it, regardless if you want to argue ourselves against ourselves, I think your bill has a very hard time of passing.
So first of all, Mr. Chairman, it's our bill. You have a bill and we have a bill, and it was a bill that was introduced to both bodies identically. So we both have a mutual responsibility for the other things that are in the bill.
Correct.
And those are very important things that I hear about from businesses as well. The workers' comp, the immunity, renters, et cetera. So I think that there is a lot more to this bill than what we've been focused on. And I would recognize that I would believe that some of those things are as important to businesses as this issue. So let's go back to my, okay, Representative Connolly had a suggestion.
Yeah, thank you, Mr. Chairman. And actually, it's just kind of an add-on. There are elements of this bill that are wholly pro-employer. I mean, that's what we really listen to in Management Council. And the definition of injury, right, to make sure that COVID-19 can be included, that the experience rating of employers, right, will not be affected by individuals being kind of laid off because of COVID-19. These were all elements that were employer-friendly, employer-driven. So kind of listening to our businesses, listening to our small businesses, the ability to kind of think about a short-term compensation program, all of those are part of this bill that were kind of employer-friendly. And so please understand that this bill is really a kind of a pro-employer bill in order to get our businesses up and running and for them to feel safe, right? Opening their doors, and also for them to protect their workers and the public. At least that's the way that I see it, as it exists right now.
I love that piece of motherhood and apple pie, and I agree fully with what you just said. But I also hear employers saying they want something more in the terms of the other end of it. And there's nothing wrong with that. I think we're in agreement on virtually all of the rest of the bill. The question is there any middle ground on this first part? That's where we've been, and that's where we went. I'm not sensing a whole lot on your end of it. And, from my end, it's likely to go to another committee. We can pull our committee where we're at, and you can pull yours. But I'm not sure we're getting anywhere other than we're all doing lots of really good things of what we believe in. Senator Nethercott.
Everyone stop being stubborn. If you want to meaningfully resolve this issue, Senator Anselmi Dalton, who is most compelled by this issue, and I think reflects the concerns of those business owners who are really on the front lines of being exposed to risk associated with liability. And so I really want her to study and review carefully the provision of 35.4.114. It may be that a previous legislature gets to take credit for providing this security to businesses in a time of pandemic, and that's okay. So that is the question that we as representatives of our states and constituents need to solve. Are our businesses exposed to unnecessary risk and liability right now as a result of us reopening in a time of pandemic, in light of what 35.4.114 states? And if so, can we solve that today? That's the question.
So I would suggest we adjourn for an hour and we will review 35.4.114 and come back to you. If that's what you'd like, that's fine.
Mr. Chairman,
That was your colleague that suggested it. Reviewing.
Well, it appears that I may or may not know. I'm gonna, at least for myself, sit down trying to pull it up here. I can't read through a statute while I'm sitting here on a call.
Mr. Chairman,
Senator Somito.
I do have it pulled up and I've read it. It says that during a public health emergency, any healthcare provider or other person who in good faith follows the instructions of the state health officer in responding to the public health emergency is immune from liability arising from complying with these instructions. The problem I have is, one, good faith is always a question of fact. It leads to a trial, and I mean, that's fine. Second, we don't have a lot of instructions specifically really for hotels. I have instructions from Holiday Inns and I'm following those, but I don't have instructions from the healthcare officer, Dr. Harris. There have been none really. So I'm just trying to say, I don't know how that immunity works for me. I do know how it works in this bill. And I think good faith, I know that they don't like the good faith language because they say that always causes a trial anyway, because then you have to debate what is good faith. I just would ask someone if they could tell me, if you could tell me, Representative Connolly or Representative Wilson or Representative Barlow, Chair Barlow, what instructions I have from the state health officer, I would be feeling much better. I would feel good if I knew as a hotelier and what I have to. I do know what instructions Old Chicago has to follow. There are ones for restaurants, and I think there are some for gymnasiums, and I think there are some for let's see, gymnasiums, hair salons. There's instructions for them. They have to do things, and I think there are instructions, but not for every business, not for shopkeepers, not for your Main Street businesses that are downtown. There are no instructions of the state health officer that they've given, unless they just say you could just have. I don't know that there's a lot, but please let me know if you guys know better than I do.
Senator Northcott, go ahead. Senator Driscoll is looking at something on his phone.
Thank you, Mr. Chairman. I think then, Senator Anselmi Dalton, then you are in good faith. You wouldn't have to do anything at all to protect your customers or employees. That's the reality of that situation. And so if there are no health orders to follow, how can you not be following them? So that's how that logic applies.
I'd like to take a break till 1 o'clock. I want to.
Yeah, can we make it 1:30? Would that be acceptable? We're coming in 10 minutes, and I don't know if we're gonna have conference reports or not, so we may be in for a bit.
Very good.
At 1:30, Rihanna, could you set that up for us? 1:30?
Mr. Chairman, I'll send a meeting appointment for 1:30.
All right, thank you.
Thanks
Thank you,
very
colleagues.
much.
Thanks to the public for participating.